Welcome to BusinessTraining.com. This video module is focused on the Family and Medical Leave Act, or FMLA. This is our agenda for the video topic today. Please take a moment to review the outline. The Family Medical Leave Act, or FMLA, was enacted in 1993, and it requires that certain employers must provide job-protected, unpaid leave to employees due to a serious health condition of a family member or the employee, or to care for a new child. It is administered by the Wage and Hour Division and enforced by the Department of Labor, as well as private litigation in state or federal courts. It was developed as a way to protect employees and their jobs with their growing needs of a balanced family, work, and other obligations. The Family and Medical Leave Act applies to all private employers of 50 or more employees that work within 75 miles of the work site. Individual state requirements may be more stringent on coverage requirements, dropping to as low as employers of 10 to 15 employees as a qualifier for FMLA coverage. Always check with local state laws. State and local governments, as well as public and private schools, will automatically be covered under the Family Medical Leave Act and do not have to pass the 50-employee criteria or less dependent on the state. The employees that are eligible and covered employers are those who have worked for at least 12 months for the employer and have worked at least 1,250 hours during the last 12-month period. Non-eligible workers and non-eligible types of leave can include any of the following. Employees in businesses that have fewer than 50 employees or fewer than the minimum state requirements are ineligible. Part-time employees who have worked less than 1,250 hours within the past 12 months before the leave or less than 12 months with the employer are also ineligible. The types of leave that are not eligible for Family and Medical Leave Act include leave that is requested to care for seriously ill elderly relatives, such as aunts or uncles, or seriously ill pets. Leave requested to recover from a short-term or common illness, or to care for a family member with a short-term or common illness, such as a cold or flu, is not eligible. And time off for routine medical care is not covered, such as a dental or health checkup. The Family and Medical Leave Act allows employees to take up to 12 weeks of unpaid, job-protected leave each year for certain qualifying family and medical reasons. There are a few basic entitlements an employee may request FMLA for. Employees may request FMLA leave for the birth, adoption, or placement of foster care for a child. This includes employees that are in local parentis, which is in place of a parent, and can include step-parents as well as same-sex partner parents. In local parentis relationships may be established by providing day-to-day care or financial support where the employee intends to assume responsibilities of a parent with regard to a child. In local parentis can often fall under interpretation issues with employers and courts and is recommended for employees to provide a solid argument for in local parentis relationships. The next reason for FMLA leave may be requested to care for a son or a daughter, spouse, or parent with a serious illness or health condition. The Family and Medical Leave Act does not apply to same-sex partners or couples. However, some states extend rights to civil union and domestic partnership same-sex partners as well as different-sex couples. The FMLA, again, however, provides no such distinction or provided coverage. It also does not apply to pregnancy or prenatal care as a serious health condition if they are unmarried partners. Again, some states do recognize domestic partnerships as eligible. An employee may also choose to take FMLA leave for his or her own personal serious health condition. A serious health condition is defined as an illness, injury, impairment, or physical or mental condition that involves either an overnight stay in a medical care facility or continuing treatment by a healthcare provider for a condition that either prevents the employee from performing the functions of the employee's job or prevents a qualified family member from participating in school and other daily activities. The National Defense Authorization Act of fiscal year 2010 amended and added the Family and Medical Leave Act to provide two medical leave entitlements. The first is a military caregiver family leave, which states that employees whose spouse, parent, child, or next of kin who is a military service member who suffers from a serious injury or illness on active duty are able to take up to 26 weeks of unpaid, job-protected FML leave to provide care for that service member in a 12-month period. The next military leave entitlement is a qualifying exigency family leave, which states that employees whose spouse, parent, or child is a military reservist or National Guard member who is called to active duty for military service, may take up to 12 weeks each year to address a qualifying exigency. Qualifying exigencies can include issues that arise from a military member receiving short notice of a deployment in 7 or fewer days. This exigency can provide up to 7 days of leave for the employee. Other exigencies include military events and activities, such as official ceremonies or events sponsored by the military, family support group, or assistance programs, which are related to the active duty or call to active duty status of the covered military member. FMLA leave may also be taken to qualify childcare and school activities that arise from the active duty, such as arranging for alternative childcare, providing childcare on a non-routine, urgent, immediate need basis, or enrolling or transferring a child to a new school. The employee may also take leave to make or update financial or legal arrangements to address a covered military member's absence, such as in preparing for powers of attorney, transferring bank account signature authority, or preparing a will or living trust. The employee may also take up to 5 days of leave to spend time with the covered military member who is on a short-term, temporary rest and recuperation leave during the period of deployment. FMLA can also be taken to attend certain post-deployment activities, such as a post-deployment ceremony or return ceremony within 90 days of the termination of active duty. Any other additional activities that the employer and employee agree upon as a qualifying exigency for the covered military member may also apply, so long as it is mutually agreed upon and contracted in writing. The qualifying exigency family leave entitlement only applies to reservists or National Guard soldiers, not to active duty soldiers. The Family and Medical Leave Act has certain requirements placed on the employers. The employer is required to reinstate the employee that has taken the FMLA leave into the same job or an equivalent job if the same job is no longer available. The equivalent job must have the same equivalent employment benefits, pay, and other terms and conditions of employment that were in place in the other position upon the completion of FMLA leave. Use of FMLA leave cannot result in the loss of any employment benefit to an employee that accrued prior to the start of the employee's FMLA leave, nor can the employer discontinue any group health plan coverage that the employee would have continued to have had if the employee had not taken FMLA leave. The employer cannot interfere or take adverse action against an employee exercising their rights under the Family and Medical Leave Act, such as firing or blocking a promotion for the employee. The employer cannot also retaliate against an employee that files a complaint, gives information to, or testifies in relation to a complaint against an FMLA violation. The employer may, however, request medical documentation for FMLA leave that is taken to care for an employee's spouse, child, or parent who has a serious health condition or for the employee's own serious health condition. Employers will be held liable to reimburse any monetary loss incurred, equitable relief, interest, attorney's fees, expert witness fees, and court costs, and may even be held liable for liquidated damages for violations of the Family and Medical Leave Act. Employees do have some requirements and obligations under the Family and Medical Leave Act as well. Employees are required to provide notice of their intent to take FMLA leave not less than 30 days before leave is requested to begin. If that is not possible, it must be as soon as practicable in the case of emergencies. Employees must also provide sufficient information for the employer to determine the qualifications for FMLA leave, the anticipated timing of leave, and the duration of leave. The information that is provided to the employer should provide as much information as possible. Information should include why the employee is unable to perform job functions, why the family member is unable to perform daily activities, the need for hospitalization or continuing treatment by a healthcare provider, or the circumstances supporting the need to request military family leave entitlements under FMLA. If an employee feels their Family and Medical Leave Act rights have been violated, they may file complaints with the Department of Labor, or they may file a private lawsuit in a federal or state court. If you would like more information on the Family and Medical Leave Act, please go to the Department of Labor website at the following link. Thank you once again for your time and attention, and this is BusinessTraining.com, where you can earn a master's level qualification to make more money.